Hey everybody, it's Jason Cruz here once again with another episode of The Legal Submission. And as always, if you would be great if you guys would visit MMApayout.com, like and subscribe to my YouTube channel, and then subscribe to the Substack that you will see at the end of this video. And now we are going to be talking about an order to dismiss in a combat sports lawsuit. And no, it's not the UFC lawsuit. It is MLW, Major League Wrestling Media's lawsuit against the WWE alleging antitrust injury under the Sherman Antitrust Act, Section 2. Now, you may or may not have been following this case, but MLW filed a lawsuit in the U.S. District Court of Northern California, San Jose Division, is relating to the WWE and predatory tactics it has done in trying to carve out competitors in the sports entertainment, professional wrestling landscape. Now, when the lawsuit was filed a couple years ago, and what had transpired is the WWE, of course, filed a motion to dismiss the lawsuit. MLW opposed the motion. The court actually sided with the WWE at that time with how the motion was pled by MLW, basically how they wrote the motion. But the court allowed MLW to amend its complaint, basically change or make changes to the complaint to provide it a little more meat to the allegations against WWE, and so leaving to amend the complaint and refile if it so wishes. Obviously, MLW stated that it would and did file a first amended complaint. WWE, in turn, filed a motion to dismiss the first amended complaint, basically saying the same things that it had in its the first motion to dismiss. So to give you some background on the lawsuit, MLW is a wrestling league that is trying to carve out its own niche in the professional wrestling sports entertainment landscape. It had a couple small deals for television distribution rights. The first one it had was with Vice TV, as people know Vice TV mainly because of Dark Side of the Ring, and it's one of the most highest rated programs on the small Canadian network, Vice TV. MLW had an agreement to air some of its library on Vice Television. However, soon thereafter, WWE, according to the MLW complaint, had imposed its will on Vice TV, essentially stating that Vice had to take MLW off of its programming schedule. Otherwise, the WWE would be angry and essentially not give its blessing to the Dark Side of the Ring. The second episode here is where MLW had attempted to get another deal with, I believe it was Tubi, Tubi, a company that was under the umbrella of Fox Network. And as we know, WWE SmackDown airs on Fox Friday nights, and WWE essentially imposed its will once again with Tubi, basically stating that in the complaint, MLW said in the complaint that Stephanie McMahon had reached out to executives at Fox in order to find a way for MLW to be axed off of the Tubi programming. So that happened as well. MLW does have a television distribution deal in North America with Reels, or I believe the Reels network. It's a modest deal. Doesn't get a lot of viewership as WWE does on the USA Network or Fox Network, but still has that particular deal. Now, the issue in the lawsuit alleged by MLW is a couple according to the lawsuit. Media rights deals for professional wrestling programs generate about $725.3 million per year. According to the complaint, WWE received $670 million, or 92% of the total yearly revenue, by way of licensing deals with Fox, as well as NBC Universal, NBC. AEW, according to the complaint, its licensing deals with Warner Brothers Discovery generates $43.8 million per year, or 6% of the total revenue, and the remaining professional wrestling promotion companies receive a combined $11.5 million per year from deals with Access TV, CBS, the CW, Paramount Global, and Sinclair Broadcasting Group, among others. Now, according to the complaint, according to MLW, WWE's current TV rights agreements are valued well above competitive levels in comparison to AEW deals, and they are also more than 3 times greater than WWE's own prior TV rights agreements. So, what can we glean from that information? 1, media deals for professional wrestling are very lucrative at this particular time in the market. 2, the WWE has basically a monopoly over the market. Now, not an illegal monopoly. You can have a monopoly over the market. It's just dependent on whether your conduct is anti-competitive or not. You can just carve out everyone in the market if you're doing that in a competitive fashion. And according to the complaint, 92% of the media deals media deal revenue is generated from the WWE. And even with AEW and its great fan base and its upstart level, and it's generating more of the 18 to 49 demo with its programming, it still pales in comparison to WWE with a 6% revenue market share. That's not that much. And that leaves 92 plus 6, 98%. That leaves a 2%, a scant bit for the others, such as MLW, to carve out its own niche as far as a distribution deal. Still, 2% of a $725 million yield is pretty good. MLW also says it has an issue with its actual current television distributor, Reels. So currently, MLW has a cable deal with Reels and also streams content on Pro Wrestling TV, but we're really focusing on Reels here. So on February 28, 2023, Reels announced a distribution deal with streaming service Peacock, which is, as we know, is owned by NBC, one of the WWE's media partners. So MLW alleges its content is excluded from the deal to stream Reels programming on Peacock because WWE has exclusivity in the category on Peacock. MLW states that it reportedly at risk of losing its deal as a result of WWE's exclusivity agreement on Peacock. So here we go. As we know, Peacock Network is online, and WWE airs its premium content events on Peacock Network. And soon we'll see a change here as Peacock will go toward more of a subscriber-based model. And now, not now, but basically, MLW claims that its content, its wrestling programs, are not going to be housed on the Peacock Network. So this would preclude MLW from garnering any fans or anyone that would be puttering around on the Peacock Network because they are excluded from being on the Peacock Network due to an alleged deal from WWE that it would be the exclusive media partner of Peacock Network, meaning no other professional wrestling programs can be on it. Let's work a little parallel here. ESPN, who I've reported, who is reported to have both deals up with PFL and the UFC. PFL has recently let its negotiating window with ESPN go, or vice versa, and the UFC is coming up on its window of negotiation with ESPN up in 2025. Now, these two entities differ, but are on the same streaming service, ESPN Plus. So here, in this particular lawsuit with MLW claims that they cannot be on the Peacock Network because the WWE has either told NBC Universal or the Peacock Network executives you can't put any other wrestling programming on there, or it was caked in the deal at the outset as well. So also the MLW alleges WWE restricts its competitors' access to both distributors and content creation inputs, such as skilled performers and performance arenas and venues. Now, we've seen something similar to this in the Golden Boy antitrust lawsuit, where there were claims by, I believe it was Golden Boy, that the PBC were accessing arenas or securing arenas that they knew that Golden Boy wanted at a certain point, but were basically reserving them just because they wanted to make sure that their competitor could not. So it's similar, and in a similar fashion in the MLW lawsuit, the WWE was acquiring talent or taking talent that that MLW wanted, just as a means to preclude MLW from utilizing that particular talent. Now, let's get to the court ruling that occurred, because they denied the motion to dismiss the First Amendment complaint of WWE. So they sided with MLW in this particular case, stating that it had sufficient facts pled in their First Amendment complaint to allow the lawsuit to go forward. So what that means, from a bigger perspective, is that discovery will actually happen. And through that discovery, MLW hopes it will uncover issues or facts which would support its claim at the outset that the WWE has used anti-competitive measures to gain a big share of the pie. So, from the first part, we're talking about Sherman Antitrust Section 2, if anyone really is into that. The issue of relevant market comes up on the part of the court, because the WWE claims that their market is broad, that it is not just professional wrestling, it's more about sports and entertainment. So it's so rather than it precluding itself from just professional wrestling television, it's also talking about more along the lines of what sports entertainment would be, and sports in general. So obviously that you have a narrow focus versus a broad focus, and the court sided with the narrower focus of MLW. And so basically it states that MLW alleges a relevant product market defined as the sale or licensing of media rights for a professional wrestling program, whereas WWE said sports entertainment, professional wrestling program, and a relevant geographic market of the United States. The relevant market includes the media rights of professional wrestling TV series and programs that are aired on U.S. national television networks, U.S. cable and satellite television networks, pay-per-view purchased by U.S. households, and U.S. streaming services. So they side with MLW's definition of the relevant market, which is a key part of identifying an antitrust issue, is that you must identify the particular market it is addressing. Now, WWE had argued that it didn't sufficiently allege the purchasers of the relevant product, that television network that television networks and streaming services and that have no reasonably interchangeable content alternatives to wrestling programming. They stated that the small fraction of media platforms that air professional wrestling view other content as reasonable alternatives. So reasonable alternative is professional wrestling. Like I said, WWE wants to have a broad viewpoint of this particular market. The court disagreed. Although professional wrestling media rights markets may be narrow, the court may reasonably infer from the First Amendment complaint's allegation that other forms of programming content are not economic substitutes for professional wrestling. Importantly, MLW defined this relevant market by explicitly distinguishing it from reasonably interchangeable substitutes, which was key in this particular point. MLW was very keen on making sure it defined its market correctly. So let's go to the issue of monopoly power. Now, as I stated, you can have a monopoly so long as that you do not use anti-competitive means to get that part of market power. So the WWE argued that the complaint failed because it did not allege sufficient direct or circumstantial evidence of WWE's power in the professional media rights market. So MLW claimed that it did, and the court found that MLW had sufficiently pled circumstantial evidence of WWE's monopoly power. Now, this is circumstantial versus direct evidence. Circumstantial evidence essentially infers that the entity could be right. There's no direct evidence showing that they're right. It could be right based on the set of circumstances set up by the party. So, defendant argued the MLW must allege facts explaining why revenue share is an appropriate measurement of market share, but cites only to cases that evaluate the proper market share metric based on factual findings. So this is really more of a legal analysis as far as how they found the market share, how and why they found the market share. So MLW's allegations of revenues generated from the sale of professional meeting rights and WWE's 92% share of that revenue are sufficient to show dominance in the market, and obviously that's a big slice of the pie. Again, of the $723 million attributed to professional wrestling media rights, WWE has 92%. So in addition to defining the relevant market and alleging WWE's dominance in that market, MLW also sufficiently alleged barriers to entry as required to show circumstantial evidence of the market power. Plaintiff alleges that WWE has used its dominant stature in the market to prevent competitors from accessing certain distributors and arenas. So basically, they did show that based upon these key factors of they were on Vice and then they were off Vice, that they aren't on Peacock Network because Peacock is owned by NBC Universal, and they cannot, and they are not on Peacock because WWE is on it. That's an inference that there's an exclusivity. The Tubi agreement, in which Tubi is owned by Fox, and they couldn't be on Tubi because of the relationship WWE had with Fox. Those are inferences, circumstantial evidence that hold muster in the lawsuit. Now let's go with the anti-competitive conduct. The WWE argued that there was not substantial foreclosure of either upstream or downstream market needs. So that they're talking about content distributors or inputs like professional wrestlers or arenas. So there was also a state law claim that wasn't related to antitrust, and that is a claim of intentional interference with contractual relations, intentional interference with prospective economic advantage, and unfair competition for failure to state a claim. And those are state level claims, and WWE indicated that they wanted those claims as well thrown out. Problem here is that the court stated that the WWE did not assert any legal argument. The court stated that the WWE did not assert any legal argument on the position, but instead respectfully directs the court to its prior briefing on these counts and incorporates them herein by reference. Well, guess what? The court didn't incorporate them by reference. As it stated, the Ninth Circuit had held that a party may not incorporate by reference legal arguments asserted in prior briefs. Yikes. So, because the WWE did not include its arguments, the court did not address them. And therefore, the state law claims are upheld on the basis that the WWE did not assert them in the brief. So what happens next? Discovery occurs, and we will see from that discovery, basically written discovery as well as depositions of individuals with knowledge of the issues in the case, that if there is a particular basis for these claims. Now, this is a motion to dismiss, so the level and standard for which courts would dismiss a lawsuit are less less fact intensive, less detailed, I guess you could say, from a layman's viewpoint, as opposed to a motion for summary judgment, where a summary judgment occurs after discovery had completed for the most part. And from that, WWE probably assert that even if there is discovery, there is no issue of fact to go forward, and as a matter of law, the case must be dismissed. So that's what the WWE is now looking forward to. But the problem is they are now having to expend a lot of litigation costs with this lawsuit against MLW in the form of hiring lawyers to produce all these documents and take these depositions as well. We will continue to follow this for MMA Payout, MMAPayout.com. Once again, this is Jason Cruz for the Legal Submission. Have a great day, folks.